92.1. In a criminal proceeding, where a tape of video recording or any other material, whether produced or recorded mechanically, electronically, digitally, manually, or otherwise, is relevant to an issue in dispute, it shall be open to either party to replay such tape, video, or other form of electronics recording, or other material to the court, and the same shall be received in evidence. And same shall be received in evidence. So, Mr. Speaker, honorable members, AG, I really want to commend you for this innovation. I think it can help in the 21st century. In most cases, in advanced places, and this really have to do the person's right. If I really have, as I said it earlier, my case is as good as my evidence. So if you allow me to produce some of this evidence in the electronics form like we have now, these are things that you cannot deny. In fact, on the ongoing trial now for the coup, it's going on. Is that AG list? I have problem with people not going to court, especially those who are prosecuting, to punish the accused persons. You will say somebody because of influence, they will go to the magistrate or to the state magistrate, for example. Say, today I'm not coming for various excuses, and the person will still be in detention. Still not giving bail. And the magistrate said, "No, continue." But I'm saying, in non-appearance, that's why the judge, the magistrate, the judges, they have a discretionary issues to do. And this discretion should be done with your conscience and serving God. If your conscience is very clear, you can say, my defendant or prosecutor, you should come to court. Or if he doesn't come to court, give bail to the individual. Give bail. Because non-appearance is also a way of punishing the accused person. So this long delay of people in courts, they are not coming, the prosecutor is not feeling right. We have to look at these ones. So clause 95 is also making mention of these ones. Mr. Speaker, honorable colleagues, when a magistrate is seized with a case, they are not given a time frame in which you can operate for committal of proceedings. That is clause 112. Clause 112. 28 days is given. You have within the 28 days, you are also given 14 days of evidence that you can submit so that you can appear for hearing. In a case you have to serve the defendant, you are also given 14 days within the same 28 days. This is novelty. But you are given another additional time if you have some problem, another 7 days added. But within 28 days, you must start the case, that is committal of this offense. That we have to listen to proceedings in the court. So some of these things is stated in clause 112. As I said, sometimes I feel pity for people who are just in court and they are not in charge. The prosecutor can come, today we go around and we adjourn. The person will still be in incarceration. And we come another time, the prosecutor is not feeling well, and the magistrate is still holding on the accused person. These are some of the things that we need to observe. So in terms of conscience, you need to give bail. That's what is addressing clause 95. And clause 112, make a reference to the period which you can start committal of this offense. Then you can start trials. So if you think 28 days you should start trial. Because as I said, justice must be accessible. We don't want to make it expensive because the public will never get justice. Mr. Speaker, there is another novelty, very interesting, and I will read a portion of it. Making statement, clause 114. A statement. In most times when prosecution is going on, when you're in court, that is the time you realize that, honorable members, please, you have the members' lounge to have your private discussions. And the chamber is for us to make our contributions. Please. If I want to make a statement, when you start to get strong, for the very first day they are taking a statement in the police. Then I said, with the massive education. It's okay, forget about the literate. Someone who's literate. They can read, you can make my statement and you say, let me read. In fact, we need people to understand. I can write my statement myself and submit it to you. That this is my statement. It's acceptable. But anytime, even of those who are educated, when they go to the police station, they will say, "Oh, I'm going to make statement," and the police officer will start to make the statement. Some people are very crafty. They will say, "No, let me write my statement," because they are aware. That's why I said this law has to do to our civil liberty. But in situations where you are illiterate, you don't have the opportunity to go to school, you cannot write, you cannot read. Clause 114 makes provision, not only those who are illiterate, they have categorized it in different forms. If you are illiterate, you must have somebody to mark for you that this is your statement. They can read it to you, but somebody in a language in which you can understand. So they are going to say that you can have another person who can assist you. But there's another issue that has to do with those who are blind, those who are deaf and dumb, in these same provisions. They are saying, if you read it to me in the language I can understand, it has to do with somebody who can mark it. Somebody who can be as a witness for my statement. Because if I present the wrong statement for you in the court, so the magistrate or the judge will charge the case. So they can deal with you, so they can prosecute you. So, Mr. Speaker, with your leave, let me just read one that has to do with the blind persons. Clause 114. Clause 114. Go to C. Okay, fine. Page 65, Mr. Speaker. Page 65B. I will just use the word for the blind. In case of a blind, the rubric, it has to do with endorsement on written statement. That is a side note. Endorsement on written statement. That is a side note. B of page 65 plus D under the same rubric. That has to do with E. That has to do with the case of a blind literate person. The blind literate person. In the case of a blind literate person, this statement consisting of blah 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 pages signed by me, was made by me in the language and was read over to me, language which I admit to be true to the best of my knowledge and believe, and I make it knowing that if tendered in evidence, I shall be liable to prosecution if I have willfully stated in anything which I know to be false or not believe to be false. That is for the blind literate person. In case, that is page 66. In the case of a deaf or dim or dumb illiterate, and also those without dim, let me just use the deaf and dumb. The statement consisting of page or pages signed by me was made by me in the sign to be false or do not believe to be true. So these are some, you have a lot of them. You use mark for the deaf and dumb. At the bottom, if you go to page 67, deaf and under H, and the signature of the person who witnessed, the signature of the who witnessed, the affixing of the thumbprint or other mark. If you don't have thumbprint, so for you don't have thumbprint, for example, if they have cut off your hands, you can use your elbow if you have the elbow left, so that you can just sign with it. Mr. Speaker, these are some of the things that we need to deal with in terms of talking about judgment, talking about trials. Sections, I have these people. So I am passionate about it. That's why I'm saying thanks to them. That you cannot just take me to the police station, say I make a statement, because you think I'm not having enough fun, I'm poor, and you allow me. It must be made, Mr. Speaker, must be made on this provision. And I will be following, as Daniel said, Honorable Daniel said, we are going to go clause by clause, make sure that these are even modified in the language that we can understand. That's why I've read this provision. That is my passion. I'm dealing with them. I'm cares about their health and their well-being. So that is that. Mr. Speaker, honorable members, the issue of juror, which I will just highlight some reasons. Very recently, in the trial for hush money for Donald Trump, former president of the United States, they presented the jurors over 50. It's economically, it's not viable. I really talk about the way we are as a progressive state. Most countries are not doing, because it's not easy dealing with them. The selection of jurors. As we said, we should not politicize. We should not politicize this business of criminal proceedings. We should not. We are looking at the modern times, how proceedings are going in court. Because if they are not proper, they are not done in the interest of our people, therefore we are accusing that the court is corrupt. First selection of Jesus. These are things that are very expensive. For America, when they assemble the Jews, they want to empanel them. Delay justice denial. If you have the Jew, you have to select them. And if the trial is going on, you have to host them, you have to keep them somewhere. So that they can, because their decision as juror is final, the judge cannot change it. So then if you go back to cases that now people are saying, 25 years ago, he was convicted of murder. And he has done something like 20 years. People are still going after those cases. And they have come with actual evidence. Your evidence, your case is as good as your evidence. At that time, if the evidence is not available, at that moment of prosecution, you only tell that the evidence that you have, you are not able to get the actual evidence to exonerate that client. And 20 years after, you have suffered so much in court, and the jurors, they have made their decisions. Having kept them in place to the decision of the jurors is final. He is castrated, he sentenced. Mr. Speaker, you are a prosecuting lawyer. You know the consequences. Like in Sierra Leone, no compensation is given. In other countries, people are asking for compensations. If advanced countries are not getting it right, with all the advancement in technology, we should not afford to incarcerate our people because of lack of evidence. But Mr. Speaker, they have not refused in talking about the single trial of judges. Why? With the assessors. For I said, I have defined that you have 10. That is the quorum you have. 10. You can go as far as having 8. So you can sit. But below that, you can adjourn. But coming back to the single trial judge, please. You have right to appeal. Coming out to have assessors. They have 3 assessors. These are people, they are not lawyers, but they are experts. Assessors. They are experts in court, they can advise you. But the decision is not final. The decision of the judge is final. But you have right to appeal. Economically, the judicial system, we have to examine. You really have to examine what is good for us. Secondly, we also have to look at how in our society, the poverty mentality of our people, when you take them as jurors, the poverty mentality of our people. If they make their statement, you have nothing to talk about it. You don't have a second look at it. You have your charges against the jurors for certain issues. For example, lack of attendance in court, blah blah blah. But this that has to do with the judgment at the end of the day. And you don't have quorum. It's time consuming. So imagine if you are going to do another spectrum of judges, there's objection. Cases are supposed to take a month, 3 weeks, or 5 months. They will not take more than 1 year, 2 years, because you have to fulfill the process of having the jurors, etc., etc. Economically, you have to keep them. If the case is going to be for 6 months, you keep them for 6 months. Under conditions that you know very well, Mr. Speaker. Mr. Speaker, the other one I would like clarification from my minister. I want you to clarify for us. Well, this is no clarification. To a bit digress on it. Trial of children. Trial of children. Mr. Speaker, this is very important for us. He is repeating to Cap 44, that is go to clause 215, but he's making reference to Cap 44. And we don't have Cap 44 here with us now. But when we come to the committee stage, provide us with the substantive law of Cap 44. The trial of a child is very important to us. So you are saying, referring to us in 215, clause 215, honorable colleagues, if you go to 215, it's referring to us to trial of a child. Because people are neighbors, they have money, and you don't have control over your children most times. These are kids. So somebody, because of certain child activities, which you are the parents of self, you are not even aware of what they are doing, and if they are found culpable, in certain instances, you said trial of a child that has to do with Cap 44, the Child and Young Persons Act, Cap 44. Mr. Minister, with your leave, I may ask that dealing with this issue of child, I beg you in the name of God, that you try to expand on it when we come to this provision, this clause, we need to expand on it. Because we need to understand this is not coming to court. The DPP knows about that one. I went to them. I'm a victim of this one. So we need to understand what we do. We need to understand how to administer the law. I said it's a discretionary job. But you are frustrated because of the attitude of certain individuals. And a child who have committed an offense, maybe he doesn't even know what he has done. And he's incarcerated because I have money, I have influence. So I will go to the magistrate to say, oh, SO2 will keep our neighbors because of neighborhood superiority. Discretionary job. Mr. Minister, I am not trying to drag you off. If you cannot give us any explicit explanation, how do we deal with young persons at UNACA 44? What we can do, we can build up on it at the committee stage. Mr. Speaker, Part 8. I listened to my colleague on the other side from Kenima, Honorable Sandy, made reference to suspended sentence, and in my own remarks, in passing, I said, we are now going to look at some of the sentences to decongest our prisons, to see there are certain things that we can do so that we can have these minor offenses that we can do, punishment in lieu of payment. You don't just incarcerate, go to Panema Road, etc. No, but they have time. There are cases that have to do 2 years, below 2 years. Those are, you cannot go above that. But there are conditions given if you have to about suspended sentence. So I make reference to for suspended sentences for clause 217. Mr. Speaker, let me go read. 217 is good for us to know. These are new things that you are coming with. So we cannot just congest our prisons. These are for minor things, for traffic offenses. And people say they are not minor things. If I be determined that these are offenses that have got an accident, the traffic accident, these are things that you can have suspended sentence on. Or as I say, for neighborhood quarrel, or what is, you can say, we have quarrel and abuses, I come to court, I really in court because I have influence, I go to imprison you for 2 months, 6 months. These are things you can talk about suspended sentence. These are below 2 years of sentence. So we decongest his head. And there are more lessons that you can learn if you give them suspended sentences. 217, let me read quickly. Where a court passes a sentence of imprisonment for an offense, we are going to deal with. There is so much words are not separated by typing. Those ones you can deal with when you come at the committee stage. So if the word is an offense for which the terms of imprisonment does not exceed 2 years, the court may order that the sentence be suspended and that it shall not take effect from the date of that order, unless within 1 year of the order. The offender commits another offense punishable with imprisonment. So if you have a suspended sentence, you are guided by the law. I'm not giving you a sentence, I'm going to do the same thing. You can be imprisoned. But at the first instant, your first appearance, giving you suspended sentence, you want to make sure that let us accept the issue of suspended sentence under this provision. You can look at the modes. You can look at the modes, Mr. Speaker. There is all the levels, how you go about dealing with suspended sentences. I don't want to go over, but I don't want to draw the attention of the House to clause 217, that you can have that one. Deferment, Mr. Speaker, 218. Deferment, also there's a provision for that. There is a clause, we have the, what they have done, I must commend them, all of the team, AG. They have not given us a on pro bono basis. And the way people are thinking about that if you are giving suspended sentence, SO2, like this someone. No. No, sir. You are guided by the law, by the order they are going to give in court. So deferment of cases also. You can seek out the sentence. The provision is there also. You can read clause 218, 217. Mr. Speaker, there is another provision under it, as I said, from 217, deferment 218, and deferment that has to do with certain charges, 219. Mr. Speaker, honorable colleagues, there is a very interesting one which somebody mentioned. Community punishment, Mr. Speaker. Community punishment, 223. Community punishment. And I will read this provision. Mr. Speaker, let me entreat you. In the same provision under community punishment, it cannot exceed more than 60 days. But there is a supervisor. Somebody supervises you by order of the court. What you are going to do under community punishment. Under community punishment. It's not that it's safe for a suspended sentence, where they have to look at another modalities. When you come to community punishment, as proposed in the bill, there are modalities to follow. Let me read that provision, 223. You have 222, you have 223. Let me go to 223, Mr. Speaker. Clause 223. The side note is community punishment orders, 223. Mr. Speaker, with your leave, I read both one clause, 2231 and 2, for the edification of members. Where a person is convicted of an offense for which there is very interesting thing I'm going to read, which I know Nigeria will be very interesting to take part of this. For which the term of imprisonment does not exceed 5 years, is different from suspended sentence. This one is 5 years, the other one are 2 years. Does not exceed 5 years. The court, by or before which he is convicted, may make a community punishment order requiring him to perform unpaid work, including working on youth projects, all people's homes, correctional, and state farms, cleaning public places, such as House of Parliament, cleaning public places, such as House of Parliament, hospitals, beaches, and painting of public buildings and road signs, in such manner and for such period as the court may think fit. Mr. Speaker, go to the beach area. Here are people, you keep them in prison cells. But don't forget, we are very conscious about the human rights abuses. So there will be a special order. How do you deal with them? There will be a special order. So under this provision, that's why there is time frame given to you and orders given. How do you deal with them? So they cannot just go to the community and start to abuse them because they are being punished doing community service. 2232. The number of days which person may be required to work under a community punishment order. That's what they're referring to order. Shall be specified in the order and shall in the aggregate not exceeding 60 days. So, Mr. Speaker, they are very mindful that in as much as they are punishing you, they should not go beyond the limit. There must be a limit, and certain orders are given in court. Taking into consideration the human rights issues. Human rights, because people are going to ask, what are the human? Even abroad, they are doing community service. They are doing it. People are even celebrities. They will sentence you. Sometimes, even for suspended sentences, it's common for players in Spain, in Italy. Even Ronaldo was given suspended sentence. Oh yes. So people are asking, what is that? So they're looking at your behavior. During that period, what are you going to do? Behavioral change. How do you comport yourself? Well, if you commit same offense, one of suspended sentence, you come back and they will now imprison you. For this is community service, which by order, you know what to do. That's why they are giving the instances where you can work. Mr. Speaker, honorable colleagues, there is also an obligation, as I said, for 224, there is obligation for community. There is an obligation. I can read that provision because we don't want people. As I said, let me take a long walk so that people can understand. 224, let me read to you on 224, clause 224. Clause 224. The side note obligation under community punishment order. A community punishment order made under section 223 They are making reference to where you are getting the order from, the punishment from. Shall state the committed person shall. Let me just read A, Mr. Speaker. Be under the supervision and the direction of the officer or authority responsible for the supervision of the community punishment order. So I don't want to emphasize that it's not like when you are giving community punishment, you just go like that. You must be guided by certain principles. When you read that particular provisions, you will see all of these ones. And as I said, clause 225, payment charges in lieu of punishment, Mr. Speaker. There are certain conviction that you get. They say, for example, my colleague was mentioning about traffic offences. These ones you can look at, okay, you are convicted for a common traffic offence. Traffic offence, for example, you are supposed to use this lane and you move to the other lane, and this is one way, and you have used it for another two-way coming in the other direction. For example, Service Street at a particular point in time, you don't know, and if there are signs, you have just gone through without looking at the road signs. These are when you are in court. When you are in court, you can say, okay, you are convicted with all proofs. Now looking at clause 92, they can even produce cameras in court to show that you did the wrong thing. So they can say, okay, you are convicted for 6 months, but you can pay fine for say 2,000 euros. So this can all help to decongest our correctional centers. So, Mr. Speaker, let me say at the end that it is not taking discussional issues that we are really interested in, but we are appealing to the magistrates and the judges. When this law is enacted, AG, you have enormous power. That's why I have stated where you have your interest. How do you approach the court? I said you have the right based on the provision in the Constitution. You can enter any court under Section 64 with the powers you have to take your actions. And some of these things that we need to do so that we as citizens, we represent our people. Our people cannot suffer injustice. In as much as we don't want to make crime lucrative, we don't also want to make justice expensive. If we do, the poor people will never get justice. Poor people will never get justice. So what you are doing, Mr. Speaker, we want to make justice accessible for every Australian. Thank you very much, Mr. Speaker. Thank you very much, my colleagues, for listening to me. I have taken a long walk, and I want to have rest. The Lord bless us.
Leader of government business.
Yes, JPP.
That was a long walk indeed. Thank you very much, Leader of government business. Yes, Mr. Minister. If you have any intention to do more, you are already interacting with your lecturers. Ages all over the world are not very nice people.
Mr. Speaker, honorable members, with the greatest humility and respect, I want to say thank you to honorable members for the time that they've spent. Mr. Speaker, honorable members, just by what's been demonstrated this morning, apart from the consultations that we've had before now, it shows that yes, honorable members have spent time in reading this particular bill. I have no doubt in whatever they do or what they intend to do. But this particular one just shows that they are committed to it. And I doff my hat to the House for that. Mr. Speaker, just to answer to certain questions, to some questions raised by honorable members. And I'm of the utmost view that this bill will have to go to committee stage where we will have more opportunity to sit and discuss line by line, clause by clause, and we'll have further better understanding, not only for us, the piloters, not for the lawmakers, but for the country as a whole. Mr. Speaker, some questions were raised or concerns raised about women involved, about some women being abused in correctional centers. That I will not gainsay, even though we cannot we don't have anything any proof to show to that, but I know for a fact that whenever incidents of that comes up to our attention, immediate actions are taken, and we're not going to rest nor will sit by and allow this to happen, because an incarcerated person has a right. So the person's right continues up to the last breath of that individual. Being incarcerated does not wipe you out of your basic fundamental rights. So we'll continue to act and monitor the situation as it happens. And that is why with this new bill, should it come to law, it makes provision for further aggressive steps against predators. I will refer to them as predators, preying on defenseless people whilst incarceration. For the modernization of the courts, yes, Mr. Speaker, you will see if you walk along the streets, the main Shakasimi street, the judiciary has done a lot, but modernization does not stop there. We'll continue to augment the lifestyle of the judiciary in that provide the basis to accelerate justice for every individual in this country. Mr. Speaker, an honorable member made reference to not everybody being computer literate. And modernization does not only mean computers or providing computers. It goes beyond that. Because our thinking when we say to modernize, first thing we think is about upgrading or providing computers, laptops, iPads or so, but it goes beyond that. Now I will say, Mr. Speaker, apart from the bill, that within the judiciary website, you can log in and see your cases, see assignment of cases before various judges. You can log in and read judgments. The immediate judgments are delivered. They are posted online. You can ask questions. And I know that, again, up to this period, we will tend to work with to work the system around where lawyers will file all papers online. And your dates for hearing are also slated online. So we are on it. We are working on it. It's going to be a continuous drive process. We are not stopping, and I will be late in doing that. For the bail conditions, Mr. Speaker, this bill, like the 1965 Act or 1965 Act, with this bill now, we intend to be more aggressive in bail for any suspect, accused persons, or the like. There is a bail regulations. It's out there, but it will only take proper and actual effect if this bill becomes law through by your making. So once this bill becomes law, the bail regulation kicks in, and then there will be no question of me dictating the terms and conditions of bail, because already there are regulations going alongside with this bill. Mr. Speaker, honorable members, a particular reference was made to the question of trial by judge and jury. And I doff my hat to the majority leader in speaking to that is already in this bill. Mr. Speaker, honorable members, reference was made again by honorable leader of the House with regards section 76, talking about the delay of clause 95 of this bill before you now. And in answer to that, Mr. Speaker, in answer to the question of trial by judge and jury, the reason why we are proposing that we do away with the jury system. If we wanted to do that, Mr. Speaker and members, we could not have included it in this bill before coming here. But we want to be forthright with the people of Sierra Leone. That's why it is in this bill and I've brought it before you for your attention, subject to the argument that I will put forward with regards to that. One important argument is the question of delay. But before the delay, Mr. Speaker, there was a death penalty. The 1965 Act, apart from the Constitution that says no individual has the right to take any person's life, save the state. The 1965 Act, the extant provision, law right now, makes provision for the death penalty, and even with that, when somebody is in charge, not only with treason or murder, there are other serious offences to treason and murder that carry the death penalty. But before any individual could face the guillotine, that person must be tried by his or her peers, the ordinary man out there, not only by the law. For the judge, you tell the law, the fact is done by the convicted for murder, treason, or burglary, sacrilege, before that person could be a.
They show up for a particular day and people are granted. They fail to show up. And you have murder cases, you have treason cases that are in these courts forever. They've been there for over 10 years, 15 years. Because if all the jurors do not meet, the court cannot proceed. So if you talk about the juror system in theory, then it's a perfect system. But if you subject this particular system to practice, then it is the cause of injustice. The very injustice we are ranting about. So as far as I know, I am not an advocate for the juror system, or the jury system. It's the cause for injustice. So, but I will not say, as a matter of fact, that no, let's abolish it, let's not talk about it. But when you go to the committee stage, committee members find a way around, find a nice point between the jury system and trial by judge. Find a nice system that we can put together. So many countries tested it before. So many countries, and they abandoned it. If you go to Germany abandoned it. You go to India, you go to Singapore. This place they abandoned it because it does not work. In theory, it's good, but it does not work. It's just not practical for it to work. Because as far as I know, if somebody brings a case against me, I want that case concluded as soon as possible. So if I'm to serve my term, let me go and serve my term and walk away. But people are there forever because the jurors just refuse to meet and proceed with these cases. By pinch of salt. Yes, please.
Thank you, sir. Again, even with the current position, wherein the law says that you go by trial by judge and jury with murder, with the abolition of the Act, and in the 1965 Criminal Procedure Act, it also makes provision that if the punishment that the individual is standing trial for does not warrant death at the end, the 1965 Act gives the Attorney General the power, as of rights, as of course, to make an application before the judge to go by judge alone, even with murder, currently as it is. Maybe that was one of the reasons that I don't remember made reference to the Supreme Court. That is a right as of course. An application can be made just by filing the paper that we want to proceed by judge alone, because the end point is there is no longer death penalty. Why should we force to sequest them so we should have the facility? So when you sequest an individual, you provide everything for that person for the period of time. And let's assume that we have 12 members as a jury. The trial is ongoing. As what the speaker, the honorable speaker, alluded to, one person falls in. Again, all of us might have had that quote unquote, Speaker, with your leave, sir, if I could reference SO2, case the delay in court, because the judge did not go. They would not know that a juror was absent. The prosecution will be there, the defense will be there, the judge is there. Witnesses are available, but a juror is absent. Will have to adjourn, no matter what. And should you insist to arrest a juror, which is a right given by the court, then the rest, they will start to chicken out. They will refuse to ongoing. So the prosecution has closed. Defense comments. Midway through the defense, a juror, as per bad faith, dies. We start all over again. And then the inmates will be there, the detainee will be there, the accused will be in detention as long as this matter is ongoing. It is not about which hunting any individual or not about trying to target any person. It's because we want to be progressive, as this honorable house have been doing right through piloting and enacting progressive laws. That is the reason. Otherwise, we could have removed that and come before this house just with a bill with no jury system. But at committee stage, we'll be prepared to delve more into it and provide further explanation. Mr. Speaker, a question was raised about section clause 79.1 and 79.2 or alternative convictions, and for 79.2 for a sentence of infanticide. Mr. Speaker, the judge or the court has the power, has the right to listen. It is the duty to listen to cases where an evidence has been adduced before the court, and at the time of writing his judgment, the judge alone, in his wisdom, thinks that the evidence adduced so far does not warrant the charge that the individual was brought for. The judge can give an alternative to that. Say for murder, if the evidence I can charge for murder, just murder alone, a common law offense. But if the judge sees that the evidence adduced so far does not amount to murder, or the evidence does not convince him to charge, to sentence the person, convict and sentence the individual for murder, the court can reduce to manslaughter, even if I charge with murder alone. The judge has the right to do that. So that is what 79.1 plus 79.1 is speaking, reaffirming that position and maybe buttressing is making it more smoother and sweeter. For 79.2, again for a pregnant woman, generally we charge for murder. But again, if the judge realizes at the time of conviction, after he has assessed the entire evidence before him, realizes that no, this person cannot come in for murder. I cannot convict this person for murder. Because look at the circumstances of 79.2. Mr. Speaker, you remember with your leave. Let me just call your attention to 79.2. It says, where upon trial of a woman for the murder of a child, be a child under the age of 12 months, the jury, and where there is no jury, the court is of the opinion that at the time she, by any willful act or omission, caused its death, but at the time of the act or omission, the balance of her mind, that's the key, the balance of her mind was disturbed by reason of not her having fully recovered from the effect of giving birth to the child, or by reason of the effect of lactation consequent upon the birth of the child, she may be convicted of infanticide. The law gives the law gives the conditions, which is to be generally at the time the person was charged. The first perception was the person was did the act deliberately. The person had the intention to murder the baby within 12 months, the age of within 12 months. But subsequently, evidence were used before the court. And the court thinks that no, that wicked intention, the person did not have the intention to commit murder. The evidence does not amount to murder. Yet the court on its own can convict and sentence, can convict for and sentence with infanticide. That does not take away the right of the court from punishing the individual. So that is what 79(2) is speaking to. Alternative sentences, when the court has the power at the time to do that, cannot wait to go and come back. Mr. Speaker, honorable members, so far based on for the rights of the child of children, reference was made to Chapter 45. And I will further add to Chapter 45, the Child Rights Act. We know in Sierra Leone, the age of a child is below 18. And there are ways you cannot bring a child to an adult. You cannot try a child, even if the child commits an offense of murder. There is an instance now where that I'm privy to, when a person committed an offense of murder, the person was charged with murder, convicted. But the difficulty is the person cannot be sentenced as an adult. The person cannot be sentenced as an adult. The person is in approved school with a warrant that the sentencing of that person is at the behest of His Excellency the President. So until His Excellency decides otherwise, the person has been convicted. So there are ways. That is why Chapter 45 and the Child Rights Act are there as safeguards. In addition, what this bill is speaking to, that in an event a child below the age of 18 commits an offense, albeit an adult offense. An adult offense meaning murder or something else serious that the person can go, is supposed to go to an adult incarceration center or a correctional center. You cannot. 45 and the Child Rights Act gives you the safeguard how to treat the person if convicted and where should the person be placed. Mr. Chair, honorable members, Mr. Speaker, honorable members, except otherwise, but these are the issues raised which I think I've tried my best to provide some explanations for, subject to any other questions from the Speaker or members. Thank you, honorable members. Mr. Speaker, honorable members, I move that the bill entitled the Criminal Procedure Act 2024 being an act to amend the Criminal Procedure Act of 1965 being read the second time.
Honorable members, the question is that the bill entitled the Criminal Procedure Act 2024 be read the second time. All those in favor say aye. Aye. Those against say nay. The ayes have it.
The bill entitled the Criminal Procedure Act 2024 being an act to repeal and replace the Criminal Procedure Act 1965 to provide for new procedures relating to summary trials, committal proceedings, trials on indictment, alternative sentences, and to provide for other related matters has been read the second time. Mr. Speaker, honorable members, I stand on the S-51 to commit the bill to the legislative committee.
Any second now?
I so second.
All those in favor say aye. Aye. Those against say nay. The ayes have it.
Pursuant to SO 51-1, the bill entitled the Criminal Procedure Act 2024 has been committed to the Legislative Committee for further scrutiny.
Thank you very much, AG. Thank you very much. You may leave. Announcements. Leaders on both sides of the aisle, leaders on the government bench and leaders of the opposition, we are expected to have a meeting at 2 p.m. today with the Minister of Basic Education. Please make sure you are in attendance in the Speaker's conference room. Honorable Veronica Kadisi, Honorable Levy, please ensure that you are in attendance. Thank you very much. This sitting is adjourned to